Chapter 9. Bankruptcy is a special legal tool designed for municipalities. A municipality is a city, town, village, county, or even a school district. It can also be a public improvement district or a municipal utility. This type of bankruptcy helps these public entities when they face severe financial trouble. Unlike individuals or corporations that use other bankruptcy chapters, Chapter 9 is exclusively for these government-related bodies. It gives them a chance to reorganize their debts while continuing to provide essential services to their residents. This process is not about shutting down. It is about creating a workable plan to pay creditors over time. The main purpose of Chapter 9 is to provide protection from creditors. When a municipality is struggling to pay its bills, creditors might sue to get their money back. This can disrupt public services and create chaos. By filing for Chapter 9, the municipality gets an automatic stay. This is a legal order that stops most collection actions, lawsuits, and wage garnishments against the municipality. It creates a breathing room, a necessary pause. This allows the municipality's leaders to focus on developing a long-term solution to their financial problems without constant pressure from those they owe money to. It is a critical step towards stability. Who is eligible to file for Chapter 9? The rules are very specific. First, the entity must be a municipality as defined by federal bankruptcy law. Second, the municipality must be specifically authorized by its state's laws to file for Chapter 9. Not all states allow their municipalities to file, so this is a crucial first check. Third, the municipality must be insolvent, which means it cannot pay its debts as they become due. Finally, it must want to create a plan to adjust its debts, and must have negotiated in good faith with its creditors, or proven that such negotiations were not practical. Understanding the unique nature of this process is important. The court's role in a Chapter 9 case is more limited compared to other bankruptcies. The federal court cannot, for example, interfere with the municipality's political or governmental powers. It cannot tell a city which services to provide, or what taxes to charge. The municipality retains a significant degree of control over its day-to-day operations. The court's primary function is to approve or disapprove the debt adjustment plan, ensure fairness to creditors, and confirm that the plan complies with the bankruptcy code. This balance protects both the municipality's sovereignty and the creditor's rights. Before a single form is filed, a municipality must confirm its eligibility. This is the most critical initial step in the entire process. The leaders of the municipality, such as the city council or county board, must first look to state law. Does the state government permit its cities, towns, or school districts to file for Chapter 9 bankruptcy? This is a non-negotiable requirement. An attorney specializing in municipal law or bankruptcy will be essential in making this determination. This legal expert can review the state statutes and any relevant case law to provide a clear answer. Without state authorization, the path to Chapter 9 is closed before it even begins. Once state authorization is confirmed, the next phase involves a deep and honest assessment of the municipality's financial situation. This means proving insolvency. To do this, financial experts and accountants must be brought in. They will conduct a thorough audit of all assets, liabilities, income streams, and expenditures. This isn't just about having more debts than assets on a balance sheet. It often means demonstrating an inability to pay debts as they come due in the near future. This detailed financial analysis will form the backbone of the bankruptcy petition and will be scrutinized by the court and creditors alike. With a clear picture of insolvency, the municipality must attempt to negotiate with its major creditors. This is a requirement of good faith under the bankruptcy code. The municipality must show the court that it tried to work out a solution before resorting to bankruptcy. This could involve meetings with unions, pension funds, bondholders, and major suppliers to discuss potential concessions or payment plans. Detailed records of these negotiations, including correspondence and meeting minutes, must be kept. If negotiations are not possible because there are too many creditors or they refuse to cooperate, the municipality must be prepared to prove this to the court. The final preparatory step is to gather all the necessary documentation. This is an extensive and detailed task. The municipality will need to compile a complete list of all its creditors, including their names, addresses, and the amount each is owed. It will also need to prepare a schedule of its assets and liabilities, a schedule of its current income and expenditures, and a statement of its financial affairs. This package of information provides a complete snapshot of the municipality's financial health. It is what will be submitted to the court, so accuracy and completeness are absolutely vital for the process to move forward smoothly. The official start of the Chapter 9 bankruptcy case is the filing of the petition with the bankruptcy court. This is not a simple form but a comprehensive package of documents. The primary document is the voluntary petition for non-individuals filing for bankruptcy, also known as Official Form 201. This form formally requests protection under Chapter 9. Along with this petition, the municipality must submit the detailed lists and schedules that were prepared beforehand. This includes the list of creditors, the schedule of assets and liabilities, and the statement of financial affairs. Filing these documents correctly is crucial for the case to be accepted by the court. The petition must be filed in the federal bankruptcy court for the district where the municipality is located. The municipality's legal counsel will handle the physical or electronic filing. At the time of filing, a filing fee and an administrative fee must be paid to the clerk of the court. These fees are set by the federal judiciary and can change, so it's important to verify the current amounts. The filing of the petition is a public record, meaning news of the bankruptcy will become known very quickly. This act immediately triggers the automatic stay, which legally stops all collection efforts from creditors, providing immediate relief. Along with the petition, the municipality must also file a specific list of its creditors. This is often called the creditor matrix. This list is incredibly important because it is used by the court to send official notices about the case to everyone the municipality owes money to. The list must include the name and last known address of each creditor. If a creditor is not on this list, they may not receive proper notice of the bankruptcy filing. This could lead to legal complications later on, as that creditor might argue their debt should not be included in the reorganization plan. Accuracy is paramount here. After the initial petition is filed, the court will issue a notice to all listed creditors. This notice informs them of the bankruptcy case and provides important deadlines. It will also announce the date for the meeting of creditors, although in a Chapter 9 case, this is less common than in other bankruptcies. The court clerk plays a key administrative role in this part of the process, ensuring all procedural requirements are met. The municipality's legal team will work closely with the clerk's office to ensure all documents are properly filed, and the case proceeds according to the rules set forth in the Bankruptcy Code. Once the Chapter 9 petition is successfully filed, the municipality enters a new phase focused on developing a plan of adjustment. This is the core of the entire bankruptcy process. The plan is essentially a detailed proposal for how the municipality will handle its debts. It will outline which creditors will be paid, how much they will be paid, and over what period of time. This might involve reducing the principal amount of debt, lowering interest rates, or extending repayment terms. The municipality has the exclusive right to file this plan and must do so with the court. It is a complex document that requires careful financial and legal expertise to create. The plan of adjustment must be approved by the creditors and confirmed by the court. Creditors are grouped into different classes based on the nature of their claims, such as bondholders or employees with pension claims. Each class of impaired creditors, those whose rights are being changed by the plan, gets to vote on whether to accept it. For the plan to move forward, at least one class of impaired creditors must vote in favor of it. The voting process is formal, and the results are submitted to the court. This step ensures that those who are owed money have a say in the proposed solution. After the vote, the bankruptcy court holds a confirmation hearing. At this hearing, the judge will review the plan to ensure it meets all the legal requirements of the Bankruptcy Code. The judge will check if the plan is feasible, meaning the municipality has a realistic chance of being able to make the proposed payments. The judge also ensures the plan was proposed in good faith and is in the best interests of the creditors. If any objections were filed by creditors, the judge will hear arguments on those issues. If the court is satisfied, it will issue a confirmation order, making the plan legally binding on the municipality and all its creditors. With the plan confirmed, the municipality can begin implementing it. This involves making the new, adjusted payments to creditors as outlined in the confirmed plan. The court retains jurisdiction over the case to ensure the municipality follows through on its commitments. Successfully completing the plan leads to a discharge of the debts that were provided for in the plan, giving the municipality a fresh financial start. For more information and professional help, a municipality should always consult with a bankruptcy attorney who specializes in Chapter 9 cases. Further guidance can also be found on the U.S. Courts website, uscourts.gov, and through organizations like the National League of Cities.